This is the story of Christa Pike and envy. Generally, all of us know what envy is. It's a common feeling. It's usually harmless, but it's when you want something somebody else has, whether it's their car or you're jealous of their job. But rarely is it a motivation for murder. And that was Christa Pike. She was unstable at best, but she really went over the top when she thought another teenager was trying to steal her boyfriend. So, who is Christa Pike? She was only 18 years old and a student on January 12th of 1995 when she got jealous of a fellow Job Corps classmate, 19-year-old Colleen Slimmer. Colleen Slimmer, she thought, was after her boyfriend. Now, all of the victim, Colleen Slimmer's friends, say that wasn't true. She wasn't after her boyfriend at all, but that's what she thought. So Krista was resourceful and she got two different friends of hers, Shadola Peterson, who was also 18 years old, and to Daryl Ship, who was 17 years old. She enlisted their help. And the three of them went to the college dorm with Slimmer and said, "Hey, we want to make up, right? We're going to make peace with you. And we got some marijuana. Let's go smoke." So the four of them went to the woods. And Krista convinced them all to go to an isolated spot by an old mill in the woods. And this is at University of Tennessee campus, not far from there. So they signed out of the dormitory. And when they got there, very quickly, what happened, we know based on testimony at the trial, is that for the very next 30 minutes, Slimmer was taunted, beaten, and slashed. They even carved a pentagram into her chest. At the end of all this, Christa Pike, smashed in her skull using a big piece of asphalt. And then get this, she couldn't help herself. She took a piece of the victim's skull and put it in her pocket. She began showing it around school, and that's why within 36 hours, all three of these defendants were arrested and charged for the murder of the victim in this case. The sin, again, envy, defined as the desire for oneself and to destroy another's good fortune. It can also be part of jealousy. The why behind the crime, the motive. I'm Ashley Willcott. As a TV judge, a former trial attorney, I can tell you that almost every case I've ever seen intersects with one of the 7 deadly sins as the motive: pride, greed, wrath, envy, lust, gluttony, and sloth, the opposite of the 7 heavenly virtues. Temptations that, taken too far, turn deadly. This week, we do break down the case of Christa Pike and how that deadly sin of envy turned into a brutal bloodbath. I'll be joined by trial attorney Robert Hille in our breakdown segment to go deep on the how and the why of the envious actions of an 18-year-old. Let's get into it. This is the Deadly 7. Bob Hille, I am so grateful to you for coming on. Robert Hille is a trial attorney. You're a legal analyst. You join lots of different networks. You share your expertise. And I couldn't be more thrilled than to have you on to talk about the 7 deadly sins, specifically envy as it relates to Christa Pike. But I want to ask you, I'm going to be sharing my perspective from the bench and 5 different things we're going to talk about that should terrify anyone about this case. But before I do that, you happened to mention to me that you had a trial in which you actually utilized one of the deadly sins as part of that trial. Tell us about that.
Well, actually, my adversary went to the jury saying that my client was guilty of all the deadly sins.
Oh,
And
that's a
it was
lot.
interesting. It was very dramatic. We talked about Abraham Lincoln, or he did, and but ultimately the outcome was pretty good. But it was for our client. But it was a civil case, so it was. But there was an affair involved, a CEO, and
Mm.
there were all sorts of other interesting twists and turns that the jury got to listen to over 2.5 months of a trial before the verdict.
Yeah, it's amazing to me. Every single case I've ever been involved with in any capacity, I can say it always relates back to one of the 7 deadly, and we know because Christa Pike testified, confessed. Now later she said, "Oh, it was, it was forced," but none of the courts agreed with her. Her conviction stood, and she said, she was trying to steal my boyfriend. She was jealous because she was doing that. So the jealousy, the envy in this case is pretty well established as the motive based on what she even said. But the 5 things that should terrify anyone about this case. Let's start with the first one and get you to weigh in and tell me your thoughts, Bob. So before they even left, she enlists her 2 friends. They go to the dorm to pick up the 4th person, the victim in this case, and say, "Hey, we want to make up with you. Let's go out. Let's smoke some pot. This will be great." And when they did that, before they did it, Pike had already pocketed a box cutter and a meat cleaver. And then we know not only did they draw a pentagram on the chest of the victim in this case, but she was stabbed hundreds of times. Hundreds of times. So to me, it's the premeditation in combination with the atrociousness of the crime. Tell us your thoughts on that piece.
Well, I think it's exactly that. I mean, it starts with, as you say, envy, okay? She's and then it goes into jealousy because she has the boyfriend, but she's afraid that this person's gonna take him away, and eventually that develops into rage, but this isn't really a crime of rage because it's a very calculated process. There's a group with her that all of a sudden, gets involved, um, and she takes the instrumentalities of the crime, a box cutter, a meat cleaver. You're not going to create a lasting friendship by taking those items with you for a meeting with a friend.
But you mentioned the group. Do you think it made a difference that there were 2 other people with her? Do you think that that bolstered her ability to act in this way? Do you think maybe she wouldn't have gone so far if she'd been by herself?
I don't know. I mean, that's a great question, and this was so long ago, this crime, when it happened. What was it, 96 or something like that? So she's been in
95,
prison.
January 12th of 1995. To your point, let me use my fingers and do my math, 30 plus years ago.
Right, and, the last, discussion, I guess, May of 2024, as of that date, there had been no execution scheduled, and she had been on death row for a while. But I think that, while others that are involved in a crime, um, may help to point the fingers in different directions, that's maybe why they charged her with conspiracy because accomplice liability, you have a common purpose. So, it doesn't matter whether there's an agreement or not. You both have a common goal that you participate in carrying out. But a lot of times you get charged with a conspiracy because it's a separate offense and the
Mhm.
agreement that you then take some sort of a involvement in pushing the conspiracy to commit the crime forward and the crime happens, obviously, then, that is a whole separate offense. But here, I think it's clear, probably from the confession, as well as believing the one friend that turned on everyone, that um, she was the one who killed this person, and there would be no murder if she was not involved. So to pass it along, although one of the friends, it was very disturbing about the Satanic Bible, it was the altar, the
Mhm.
fact that the grisly part of this, where she took a portion of the victim's skull and brought it back and showed it off to people. So, and you go into her background and, you start to look at an individual that was doomed from the start, both with respect to her medical, psychological, neurological history in the womb and the abuse that she sustained there, and then a very traumatic lifestyle leading up to the date of death. Now, that's not an excuse, but you wonder what kind of things were discussed in the trial to avoid the death penalty here,
So
because
let
there
me
is a
stop
lot.
you there because there's so many great points. And one of the second, no particular order, but another thing that would terrify me from my judicial perspective or should terrify everyone listening is exactly what you just said. her background. And I mean that in two different ways. So let's talk about it on both ways. Number one, that she had to go through it. But number two, was it even considered in trial? So the background that we're discussing, I mean, she had everything, Bob. She literally had everything you can imagine. For instance, she was born with organic brain damage because of alcohol abuse while the mother was pregnant. So she starts with that. Then she has fetal alcohol syndrome, which manifests with seizures when she's an infant. And then she had an almost unbearably abusive background. That is the doctor who testified. Unbearably abusive background. She was beaten and abused by her father, her maternal grandmother, several of her mother's boyfriends. One of the boyfriends of the mother was charged with assault for punching Christa in the face as a kid. They were shuffled back and forth. She was between her mother in North Carolina, her father in West Virginia. She changed schools 12 times. And then this part, she was also sexually abused. At 18, she'd been raped twice. She'd been physically abused by at least 7 different family members, sexually abused by at least 3 individuals, and sexually abused by the grandmother's boyfriend. I mean, to me, this sounds like I'm talking about 3 different cases on court TV that we're covering where one defendant had brain damage, another defendant was sexually abused, another defendant physically abused. She literally, Bob, had everything. And yet, the fact that I find, from my perspective, shocking is that she did get the death penalty and she was only 18 when she committed the crime. Now 30 years later, we know that 18-year-olds' brains are not fully developed. There's a focus on that and it's unfair, quote, I don't know if unfair is the right word, but a lot of people say you can't assume that the undeveloped brain at 18 can't be rehabilitated because it's still growing and learning. So let me put all that out there and relate all of that stuff to your point of she got the death penalty.
Well, it's interesting too because a case that underscores this was the Cruz case in the Parkland, where the
Ugh,
jury there concluded, and there were, they had to do the same thing as the jury here, weighing aggravated versus mitigating factors, et cetera. There's a dual trial, if you will, or consideration. First, guilt and the evidence that gets admitted there, and we can talk about that in a minute, and then also what might be relevant later on. I saw no mention, it didn't appear like anything was raised concerning an insanity defense, which would have brought some of these things in there, although experts can't talk about say somebody is insane or not insane. They can only talk about what the conditions were to prove the mental problem or defect, neurologically speaking, that the jury can then conclude, may have led to things. But, so here she had all these factors, and I think one of the rapes happened when she was about 9 years old.
mhm.
And she was failed by people who trusted her. She was failed by the system because apparently she was even removed for 3 months from the house
Yep.
following something, and they returned her back there. So, these are all kinds of things that certainly would be a consideration in a penalty phase of a murder case in terms of not as an excuse. Insanity would be legal justification or an excuse if it were proven, and that's a legal theory, not a medical one. But in this case, it would be an explanation and mitigating factors in the sense that the heinous nature of the crime here and just the viciousness of the attack, you know, might be explainable in a way that's not going to get her an acquittal, but it's certainly going to get some serious consideration by a jury as to whether or not she should get the death penalty. Now, whether those things were raised in the case, I don't know. I mean,
And I
she
don't
didn't.
think she would have gotten the death penalty today, Bob. I don't. I think because of, again, to your point, the penalty, you weigh the aggravating versus the mitigating factors, either the judge or the jury, depending on the state, depending on what the law provides for in that particular state. This happened in Knoxville, Tennessee. And if those aggravating factors are outweighed by the mitigating factors, then certainly a judge can make a decision, in this case, for instance, that the death penalty wasn't appropriate. And I just don't think a jury or judge today in 2025, even with the egregious nature of this crime, would give her the death penalty. Your thoughts?
I think it's more unlikely today
Okay.
that she might get it. Um, and there's different schools of thought. Like with Cruz, I think one of the jurors maybe have mentioned, they thought it would be better for him to sit and rot in prison than to, just have him executed and put him out of everyone's misery, kind of thing. That frame of thought. But there was some pretty, as you said, egregious problems here. On the one hand, you have the circumstances of crime, which were, awful, just terrible, and the viciousness of it. And what makes it even worse is that this person planned it, and premeditation doesn't have any set time period for you to develop it as a criminal defendant. But here, clearly, it was developed over a pretty long period of time by her. And then what she carried out, now, whether or not, and this is where maybe expert testimony comes in, we can talk about when it's relevant, when it's not, the confession versus, and how that comes in and the significance of that. But, that maybe during the what did she really intend by taking her there? And then did this become rage afterwards? And did the fact that she had these other people sort of supporting her in that approach to this victim may have given her the confidence that in her mind, she was justified in doing what she was doing to this person. And she was feeling probably pretty good as she was doing it.
Yeah, which is the scary part. Probably pretty good as she was doing it. So that the third thing that really stood out to me from the judicial perspective is there was a confession. And so many viewers and listeners say, if there's a confession, why in the world do we have to waste time on a trial? Why do they get to do that when they've confessed? And she confessed to all of this. She did then say that that was not voluntary and as a result shouldn't have been considered. She lost on every appeal. She's appealed everything. She's lost all appeals. She is still in solitary confinement on death row. We're going to talk about that last, but go back to the fact that what do you tell people if they talk to you and say, okay, Bob, you're a lawyer, you have this confession, and yet in spite of that, here we are going through a trial, putting the victims through the trial, putting the family through the trial, going through the appellate process, spending everybody's time and money. What would your response be?
Well, I think first of all, with the confession, you notice they usually don't have a lawyer for the government or the state during those discussions.
Good point.
They only have law enforcement there and maybe a family member, whatever. There is no restriction on what a law enforcement interrogator can do or say in that interrogation to get the end game is a confession or solve a crime. I mean, whether they're getting important evidence or whether they're getting a confession, usually they're played back in court because what they get in the investigation to that individual becomes evidence that they feel is going to justify a conviction. And the fights in those cases really go to what happens before the courtroom with the judge. And the judge plays a real important role on it with respect to the gatekeeper. And it's all about reliability of evidence, obviously. The public doesn't have confidence in a system that is interested in a conviction over a fair and just conviction, which is based on, obviously, due process and reliable evidence that reaches a burden that society has agreed to, in this case beyond a reasonable doubt, as the one that the state's got to be held to with the federal government in a federal case. So, when you have the confession scenario, and, it's funny, the frequent flyers in the system, you notice they never give confessions in those cases. In
They
those
know
cases,
better. They know it's
in tho
gonna be used against them, and to your point that police can trick, and this bothers me. From my perspective, this bothers me that the police not only can the Supreme Court has allowed that police can use their methods in the interest of justice to protect society to not be even truthful with the defendant to try to get them to confess. That's my thing number 4 that really it bothers me. I understand the need for justice, but is it right to be talking to someone who's only accused, not convicted of a crime. And Bob, they can make shit up to say, "Oh yeah, your buddy told us this," when they haven't even talked to the buddy.
Well, and you know, that's the problem for the judge with a confession, because the only thing the judge is really concerned about is, you know, well, two things really. First was the person read their rights if they were under scrutiny for being charged. But secondly, assuming they were and they waived them, then the question is, in viewing that confession, was it obtained through coercion? In other words,
Mm.
you know, was the person being questioned answering of their own free will, or were they coerced or frightened into saying something that they really didn't believe or that wasn't true? Now, that's not to say if the court finds that there was no coercion, they weren't beaten up, they weren't threatened that their family was gonna be, executed or whatever, something that was just, out of line. So in that circumstance, um, the court's just gotta say, "Well, was it voluntary or not?" And if it was
Right.
voluntary, then it comes in. Now, cross-examination, that's what it's for, to punch holes in that confession and show that, it really wasn't voluntary, but that is a question of fact for the jury to decide. It's no longer a legal threshold to get the confession in front of that jury.
Yep, and so to your point, they had a trial, there was cross-examination, they then appealed on for different reasons, but including the voluntariness of or not of the confession. Long story short, she lost all of her appeals, so I wanna go to the 5th thing that I wanted to talk about this trial that, um, wow, is all I can say. It's been more than 30 years. Christa Pike has been in solitary confinement. She has not been put to death. That has not been changed, that sentence. Bob, 30 years solitary confinement. People would argue that's more cruel and unusual than actually being put to death.
Well, there's an argument to that effect, and she did file a lawsuit against Tennessee
Mhm.
Correction Facility of State, and there was actually settlement reached where she was gonna get the same treatment as men did on death row. So here you have a young female with a storied past who does a very terrible thing, or the jury found that she did a terrible thing. I think the evidence in this case was overwhelming, and then, of course, the other
Yeah.
part of it was that for whatever reason, the sympathetic component was never really presented, and it wouldn't be presented in the trial itself.
Right,
And
the
in
penalty
fact,
phase.
there's an argument that they couldn't even mention a lot of the things you and I talked about that doomed this person maybe to, do what she did, because that has nothing to do with, what she went out that night and did, except premeditation calls into a state of mind. So to the extent you have a state of mind and premeditation, to extent somebody could argue, well, maybe she went there, but then it shifted to rage and depraved mind, which would have taken it down a notch to a second degree, because the depravity of mind would raise it above a manslaughter charge. And obviously, this person wasn't in a position where they were a threat or some other defense could be launched. So a lot of this other background might not be admissible in that trial on guilt. And any expert that would talk about that, and she didn't get treatment until she was in prison here for this crime. And she wasn't diagnosed until she was there. So I think that, um, that's kind of an interesting thing. And get to your point to end this, is that nowadays, and as time has gone on, the visceral response that people had to this crime when it happened,
Mhm.
and the people who may be involved in it from family, friends, or whatever, time has gone on now, 30 some odd years fast forward. She's been in solitary confinement, and basically her only shot here would be to come up with some new evidence that that it could have been found at the time, and had it been introduced at the time, could have, was capable of leading to a different result, or clemency from the governor's office.
And the clemency is my thought as well. But Scott Peterson is a great example of what you're saying. He's
Wasn't it?
saying there was evidence that wasn't tested that should have been. And in fact, the court has agreed that there's at least one piece of evidence found on a mattress in the back of a van that needs to be tested. But he's arguing exactly that. Listen, there is evidence that wasn't tested, newly discovered. We need that opportunity. And he too has been in jail for many, many years. I think his conviction was in 92. I'm not sure on the date. In any event, and certainly as we've done this deep dive into the motive, the reason why a defendant committed such a horrible murder simply because she was jealous, envious, we don't forget about the family of Colleen Slimmer, the victim in this
Right.
case. Robert, I adore you, and I so appreciate your command of everything legal because I learn every time I visit with you. So thank you so much for being on today.
You're welcome, and thanks for having me.
Always.